y'all, and we're back. So hopefully, hopefully, hopefully that works. So y'all, we'll try again. We'll try again. We'll try again. Happy Wednesday, everybody. It's time for Coffee and Cursey Words. I'm excited that you're back. You're back. I'm back. We're all back. It's been just a busy week. Yep. It is. We're back to streaming. We're professionals here, people. Professional. Stuff will always work perfectly. Never. Stuff will never work perfectly. So happy that we're back. So happy to see you guys. We have a lot to talk about today. So let me know where you're coming in and what you're drinking. I'm halfway through my bulletproof coffee this morning. There's a lot to chat about. Most of the stuff that is not legal documents, I'm going to be talking about on an I Have Thoughts episode of the podcast, which is for the Patreon members only. If you want access to those, you can go get them at lawnerdsunite.com. I just put up the wrong link. lawnerdsunite.com. Oh, because it disappeared. Cool. You know where it is. lawnerdsunite.com. And you can join Patreon from there. It starts at $3 a month. It's completely up to you. But that's where the I Have Thoughts members only podcast lives. So for the stuff that's not just legal documents, I will be talking about it over there. There is a lot to talk about. I will touch on a few of them. So we definitely need Lissy. I will talk about that in just a second. Welcome. We will get to first timers in just a moment. All of you, thank you for coming in. Huge thank you to our mods. And we should just get into the topics for today. I'm going to give you an overview. But first, replay crew, love you. Thank you for being here. Here are our topics for the day. These will be time-stamped down below. We are going to talk quickly about what's going on in the Girardi case. There is a sale coming up. Yay. We have some information back about the sale from the law firm. Yay. I'm not going to do a deep dive into that. It's just a quick overview of what's going on because I've gotten tagged a lot in it like, hey, what does this mean? So I'm going to just be like, hey, this is what that means. There's a new Britney Spears motion. It's an amicus brief that's been filed. We'll touch on that and kind of do a first look. And then we're going to get into all of the Duggar motions. There are 44, 45, 46, 47, 48. There are 5 of them. Y'all, there are 5 of them. So we're going to get into all 5 of them. We're going to do an overview of those and kind of the most important parts legally, and B, the T parts. We're going to talk about both. We're going to parse both, like the information that's new, the things that don't look good for his case, and all of it. So Yep. Casey, I am doing H3 stuff on Friday because those motions, there are too many. I cannot do H3 and the Duggar stuff all today. So H3 stuff is on Friday because there is so much going on with the H3 motions. I have been reading them and prepping them, but they also need a full show of their own because there is so much there. So cheers. Let's just go. Let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. And I do just want to say part of the reason I'm not getting into the H3 motions today, because the H3 motions really do relate to a lot of YouTube creators. And there's a lot of really good legal work regarding the anti-slap motion and the motion to dismiss regarding copyright, which is one of the things I get asked about the most. So it is getting its own time on Friday because they are both really good motions, but also I get asked about copyright and fair use on YouTube all the time. So it's going to get its own space so that people who are interested in figuring out what is going on with copyright and with fair use on YouTube has a space for that. So later that will be linked down below and we will get into that. So first topic, and I am making notes of timestamps. First topic today for kind of our quick bits, because we need the quick bits. And the quick bits today are only Girardi quick bits. So today's quick bits are really all of these motions for sale with regard to Tom Girardi. So let's us do that. So when you wonder why the timestamps are right, it's because I'm writing them down right now. It didn't swoop. It was supposed to swoop. If you have been following the Girardi case, Lord Almighty, there's a lot of information with regard to it, but there have been two different bankruptcies going on since last December with regard to the law firm and with regard to the personal property of Tom Girardi. And we've talked about both. We have not talked about like the personal one as much lately. Why? Because not as much has been going on as in the law firm bankruptcy. The law firm bankruptcy has definitely had quite a lot of motions filed. But with regard to the personal bankruptcy, they are still going after Erica Girardi for personal property that could have been marital community, marital community property, things like jewelry and paintings and all of that kind of stuff. So that is still going on the Tom Girardi side of the bankruptcy, not the Girardi Keese side of the bankruptcy. With regard to the Girardi Keese side of the bankruptcy, the auction that a lot of you saw, a lot of you might have bid on, they had way more interest than they thought. They had over 1,000 active bidders, which was way more than they anticipated. But they raised over $200,000 that is going to go back into the law firm and then will be distributed out to the creditors in their order of priority, which we've gone over a little bit. So order of priority being, secured creditors, priority non-secured creditors, and then non-secured creditors or unsecured creditors. And so that's, over 200,000 going back in, over 25,000 of that. Well, before that is going to the auction company that staged this entire auction. And they sold everything. You might have seen online the lingerie that Erica was like, not mine. Lingerie was sold, bottles of wine were sold, artwork was sold, every award he's ever won, like everything inside the law firm was sold. Like I've got awards like back here. I would be gutted if those got sold off. I don't know if they would have a price. I think they have value because of the notoriety of this case at this point, but they have his awards got sold. Photos of him and Erica got sold. Literally everything that was inside the law firm got sold off. And I know people like Heather McDonald from the Juicy Scoop purchased things, and others who have been covering this case purchased stuff. I did not. I did not purchase anything from the auction. Look, what I don't need is Tom Girardi's like Lawyer of the Year award. It's just not a thing. But anyway, over 200,000 back into the law firm to be distributed out. On the personal side of that, they are going to sell the La Quinta property that we have seen play into this season of Real Housewives of Beverly Hills, because Erica was at Kyle Richards' La Quinta property saying, I love that Susan was saying, I bought some stuff at the auction. Perfect. Thank you for your help. The money goes back into being redistributed, and I'm sure the creditors are very, very thankful. The La Quinta property was brought up, and Erica was like, I've never even been there. I don't know. They call it a condo. It looks like a home. La Quinta is a gated community in the Palm Springs area, the La Quinta area, which are, they're lovely homes. Kyle Richards' home is gorgeous. And I think, didn't Kathy Hilton say, I have a home here too? Like people are like, yeah, we all have homes. So this is the La Quinta property. I did not redact out the address because it's everywhere and no one's living there, and I'm not super worried about it. So everyone, yes, Tara, everyone does have houses down there. I'm sure they Airbnb them for tons of money to other celebrities during Coachella. Somebody was saying dead plants were sold. Everything inside the law firm was sold. Everything. Heather McDonald got the coat rack. I saw her stories about it. It was fantastic. So they are now selling the La Quinta property. This document going over the sale of the La Quinta property talks about the order of debtors for this property. So the trustee will sell the property, and they will sell it free and clear of the liens and then deal with the liens. Here's why that matters. There are still liens on this property. The Ruy Gomez family has liens. There are other creditors that have liens, but they are selling the property lien free, and the proceeds will be distributed in the bankruptcy court. That means there had to be an agreement saying, hey, we're going to sell this without the liens on the property so somebody can come in and buy it, and then the money will get distributed out. The trustee has already received an offer to purchase the property for $1.25 million. So the motion is brought to authorize the sale to the purchasers. So they already have somebody on the line, on the hook, like a fish. They already have somebody who is interested in purchasing it. So they are making motions to approve the sale, and they are allowing for there to be an overbid if there's a bidding procedure if somebody wants to overbid it. So that is what this motion is really going over, is how those procedures will work. And then it goes through, there is, again, process, people. There's process. There is legal process. So this is going over all of the ways this property will be handled, the ways that you can go ahead and bid on it if you need a property, if you want a property that you want to sell or purchase for over 1.25 million as is, which means you are not going to get to go into it. You are buying it sight unseen, essentially. And then there's a very interesting breakdown of how the funds from the property are going to get sent out. And that's what I thought might be interesting for our purposes today as we're doing this as a quick bit. But it talks about the liens. The real property taxes are not due yet. Taxes, it looks like for 2020, 2021 weren't paid, so those have to be paid. The judgment to the Ruy Gomez creditors. So before the money goes into the bankruptcy estate of Tom Girardi, these things will have to be paid. And then they roughly went through what needs to be done and the distribution to the estate. This is roughly based on that 1.25 sale price. 15,000 is going to go to property taxes, 5,000 to HOA dues. I don't know if they have or have not been keeping up on those. I'm guessing if taxes weren't paid, HOA dues also weren't paid. The sale costs at 87,000, including the broker commission, trustees fees at 37,000, trustee counsel fees and costs, $330,000 for the legal fees for the trustee, trustees accountant fees, $20,000, administrative fees, $20,000, leaving $730,000 prior to split. And then pursuant to the settlement agreement, 80% or $584,000 will be paid to the Ruy Gomez creditors, with the remainder to be paid to the trustee to be held in trust for the allowed unsecured claimants of the bankruptcy estate. So the Ruy Gomez family agreed. Look, they had a lien on the property. They can say, no, we have a lien on the property, sell it, and we get 100%. The Ruy Gomez family is this is supposition on my part. It seems like trying to work with the bankruptcy trustee because at some point something's better than nothing, and they are trying to get what they need to and what they're entitled to. I mean, I don't think they're going to get the full amount of what they're entitled to, but this is the breakdown that they've agreed to. So these things have all been agreed with them. And so what they're saying to the judges, look, we have somebody who wants to buy. The Ruy Gomez family is going to release their lien on this property pursuant to the settlement agreement, allowing this to be sold. And that's what it is. So that's where the monies are going. Lawyer fees, accountant fees, trustee fees. And this is when you see people talking online about the fact that no matter what's taken, there are going to be a lot of fees in this. There is going to be a lot of fees in this for everything that happens in this, for every sale. And this breakdown, we will see when there's a buyer for the property, the Pasadena property. We'll pull this up and look at the money too, because I think it's really the most interesting part for our purposes is how this works, but also how many fees are attached to this. So that's a part of it. And it's a very real part of it because bankruptcy still costs to run. Trustees don't work for free. The lawyers hired by the trustees don't work for free. So the trustee itself costs the trustee running the bankruptcy estate still takes fees. And those fees come precedent to all of the other fees because they're trying to get back some money, which is, again, something's better than nothing. And that's where we're at. So that is the sale of the La Quinta property going on. And we talked about the fact that the auction in the law firm raised over $200,000. So that's really kind of the what's the what happening in the Girardi case. I'm sure there will be more. There were a whole bunch of new motions filed to subpoena bank records on the bankruptcy of the law firm. It'll be very interesting to see what comes from those bank records when they have a full picture of all the money that was going out of that law firm, what monies might have been going to other attorneys in the firm and things like that. So it'll be very, very interesting to see what's going on there. Are you guys ready to get into the Britney Spears amicus brief? Go ahead and put a 1 in the chat if you are ready. I'm going to catch up on the super chats I've missed before we do that. So let me get to those as quickly as I can. Yes, I've seen you guys asking about my new tattoos. I shared them in one of the last videos. I'll share some pictures on social. And I was tagged in them. If you looked at my tagged photos, my tattoo artist tagged me in them too. But yes, they're hard to show on, we got this one. Also, we're going to keep them back here because they're still healing and they're in the really cute stage of healing right now. Super cute stage. Mac's mom said, Virginia, coming in from Virginia, watermelon Mountain Dew. My license plate, unite. Untie. Get it? I'm dyslexic too. I love that. Watermelon Mountain Dew. I didn't know that existed. I need it in my life immediately. I love all things watermelon and I need it. I need it. I need to find watermelon Mountain Dew. I've never even seen that. JC said, failed my 1-hour glucose test for baby number 3 yesterday. So you're keeping me entertained during my 3-hour redo today. Bless you. I hated that 3-hour redo so much. I hated the glucose tests. I failed them with my second, but I had everything that you can imagine wrong with my second. My OBGYN and I became best friends because I saw her and the high-risk specialist. I was at the doctor almost every single day of the week with my second pregnancy. He's worth it, but it sure wasn't it wasn't even 9 months because he was early too, not as early as my first, but I hate those glucose tests. I hate them. I hate them so much. So good luck. And we will probably be here for the entirety of it. Skycaster said, these streams are my law school breaks, 1 month down and I'm stressed. Thank you for the breaks. Also having a pumpkin cold brew, a 1L necessity. Look, law school is a marathon, not a sprint. It is very stressful. Learning early on, remembering that you're learning what you're learning, but you're also learning to manage stress. You have to do those things together. Do not just push it all into a box and be like, I'll deal with it later, because eventually your body will stop letting you do that and it will pop up in the weirdest ways. So take breaks. And yeah, we're taking breaks and still talking about the law. JC, I'm also doing a 3-hour glucose test right now. Good luck with your baby. You guys, everybody doing their 3-hour glucose tests. Hang in there. Hang in there the most. I love that. Everybody's ready for Britney. All right. I see one more super chat that I'm going to try to find because it came in, and then we're going to get to Britney. Earlier in the chat, I asked for a motion to hit the gavel, glasses to show you've done the YouTube fun things, and exciting to see the support. Absolutely. Do the YouTube things. You know what? If you guys can't chat, I have the subscriber chat feature on right now just because we have less mods on Tuesday and because as we get into the Duggar stuff, look, it's not y'all that don't act right, but we don't need people coming in here with the death threats and all the stuff. So that's why. So if you go ahead and subscribe, let me look, we are pretty close to 154K. So this might bing while we are on stream, which would be we're really, really close. So if you guys are watching and you haven't subscribed, go ahead. We're very, very close to making it bing, and that will probably happen this stream. So do the YouTube things. Somebody asked about my tattoos. I will share that on social, but also Iron Horse Tattoo. I love Tony. He's the best. Shout out to everyone over at Iron Horse Tattoo. We love you. So we're definitely going to bing this today. We should lippy. All right, let's talk about this amicus brief with Britney. Because question, where are the Pawnards? The Pawnards are running around with Brian doing the things. So That's what they're doing. Because that's what they're doing. And I've got the door shut. So whether they work their way in or not to distract me, I don't know, but they might. But we have so much to go over today. I'm trying very hard to not get distracted. It's a lot of motions. Look, the Duggar motions are so much, you guys. It's so much. Let's get into this Britney motion. We are going to do a cursory look. If we need a deeper dive, we'll do a deeper dive. I have not gotten all the way into this. I have seen this attorney on Twitter. I know she comments on this case quite a lot on Twitter. So we're just going to get into it and give it a first look. This is a first look. First look. So Britney Spears' dad filed a motion to terminate, or a petition to terminate, the conservatorship. We talked about it while I was on vacation. I will put the link down below for that video if you haven't seen it. It's also on the Britney Spears playlist on this channel. We will make sure that we have it. Mods, just put in Slack that that I need to put that link there. Appreciate it. Thanks. Otherwise, I'll forget. And this is filed as a friend of the court, or a friend of the motion, saying, "Hey, Your Honor, I know that James Spears filed all this stuff, but we're filing more stuff." So this is filed by Lisa Carley, executive director of Betty's Hope, a charity, and this is in the interest of the court and as a friend of the court. So let's see what the interests of the amicus are here. Betty's Hope was created. This printed funny. I don't think it was the scanning. I think it's the printer that printed it funny, but you see what I mean? Anyway, the little things that bother my eyes, but it's on gloriously spaced 28-line paper that lines up. And don't we love it when our lines line up? I mean, mostly lines up. Close enough, close enough, close enough. Betty's Hope was created to advocate for the correction and reform of California's probate courts and probate and equity courts throughout the nation. Specifically, it's become abundantly clear that the present system of allowing and encouraging judicial officers to train, select, appoint, direct, and compensate counsel has led to a veritable plethora of ethical and constitutional violations that in turn lead to horrific outcomes for persons facing or in conservatorships and their families. The untoward conservatorship of Britney Jean Spears, hereinafter Miss Spears, is a case directly on point. The mission of the charity is to work for a better system, is to ensure that every person facing or in a conservatorship is represented by a lawyer who's trained, supervised, and held accountable for their misfeasance or even malfeasance, as the case may be. Under the current system in Los Angeles County and others, judges are at once the triers of fact and obscenely dependent on reports written by court-appointed counsel. Presently, there is no agency, person, or entity at all to report concerns about the competency and efficacy of court-appointed counsel. The primary purpose of this brief is to supplement and educate the court. Oh, the court, I'm sure, will take well to being educated by an amicus. Not that it's not needed. I'm just reading how a judge and judicial assistant might read that. So the second purpose of this brief is to request that California Governor Newsom, Chief Justice, okay, well, that's not the place for this. California Chief Justice Tani, Sakuye, I think, Judicial Council of California and the State Bar of California immediately convene a public hearing to discern exactly how it came to be that the entirety of the Los Angeles County Superior Court's probate department ran roughshod over Miss Spears' constitutional rights, depriving her of life, liberty, and property for 13 years. Yeah, that's not going to happen, but go ahead and demand it all you want. The problem is, once you get to the first two paragraphs, the court might just be like, yeah, no. Yeah, no. The probate court does not have valid jurisdiction over Miss Spears. Miss Spears has never been served with a citation as mandated by the probate code. The court, in my reading back through all of this, this has come up a lot. The court decided that Britney was not to be given notice. And it looked like the reason the court decided Britney was not to be given notice in more recently unsealed documents was that they didn't want Britney to tell Sam Lufty about the conservatorship because he would try to intervene and or stop it. And it was the position of the conservatorship at that time, dad, mom, whoever, that it binged. Did you hear it? It binged. I'm going to finish my sentence and then it binged. Thank y'all. See, you made it bing. You made it bing. So and there's a little fly in here that's got very excited about that bing as well. Fantastic. That's going to be a joy the rest of this live stream. The conservatorship didn't want him to have notice of it. They were trying to keep him away from it, and they were telling the court that he was part of the problem. So that was part of the noticed provision with regard to the citation issue that's being quoted here. So let's celebrate the bing and then get back into this real quick, because you know what? It did bing. It did bing. Oh, it binged. Move your head. Ah! I also can't believe that we're at like 154,000 subs. You guys, I appreciate you so much. You blow me away. Thank you for making it bing. Let's pull this back up and get back into this. I think the court dealt with this notice provision. I also didn't agree, but they found that notice didn't need to be given to her. Other attorneys have tried to take this to federal court at that time in 2008 and deal with it. This is probably beyond statute of limitations, but at least somebody's bringing it up. Attached as Exhibit A is a true and correct copy of the citation that was filed by James Spears and counsel on March 10th, 2008. The second and third pages reflect that it was served on Sam Ingham, but was not personally delivered to Ms. Spears as required by law. Not a single lawyer, judicial officer, staff member of the probate court noticed the submission or did notice and did nothing. I don't know if she was required to be served with it because the court found that she was not to be given notice. So I don't know how well taken that will be by the court, but again, I disagree. She should have been given notice, but I don't think it's a constitutional error that's going to be a huge issue. So all right. The failure to deliver the citation in person is a defect that invalidates the entirety of the conservatorship because they never had jurisdiction. I don't know if the court's going to be like, you're right. We never had jurisdiction. Great. I just Jessica said, but if it was voluntary, shouldn't she have been given notice? Yeah, you make an excellent point. The things that happened at the beginning of this conservatorship raise a lot of questions. It all seems very suspect to me. I just don't know if the court at this point will say, oh yeah, you're right. We're going to invalidate the entire conservatorship. There are still a lot of questions to be had, and there is a lot more work to do because again, yes, voluntary, but also, we don't need to really tell her what's going on. Mrs. Spears' right to counsel was violated. Ironically, paragraph 4 of the citation clearly states you have a right to appear and object. You have the right to hire an attorney of your own choice. Again, it's a point well taken. She was blocked from hiring her own attorney. I think this is the purpose of this motion might be, and I should just ask on Twitter, the purpose of this motion might be more to put the court on blast. Matthew Rosengart has not been putting the court on blast. He needs the court to do things to work with him, and literally calling the court out on the carpet does not work well if you have to continue to appear in front of the court. But as an amicus, you can call the court out because you don't have further stake really in the case, and you don't have to appear further. And I think that this is as much for the court as it is for the public, but like, look at what's happened here. Like, piece by piece by piece by piece, and calling it out so that the entire public can see. On February 1st, 2008, the probate department issued an order appointing counsel. A true and correct copy is attached. As always, As was always the done during these years with cases involving celebrities of vast wealth, Sam Ingham, the probates department favorite, was appointed as Miss Spears' counsel. The footnote is, in addition to the obvious bias in favor of Mr. Ingham and a few other attorneys, Justice Maria T. Stratton also revealed at a training program that these judicial officers had a secret blacklist of lawyers who were not to be appointed as PVP counsel, as it was called during that time. I mean, okay. There might be a lot going on here behind the scenes that will come up, but if that's what's going on, if the judges have like a very small little list, then it definitely could lean towards showing favoritism. There is not now and never has been statutory authority for a judicial officer to appoint counsel on the same day that a petition for appointment is filed. In fact, the obvious interpretation is that court-appointed counsel is a safety net for persons who do not have counsel, meaning you should have time to get counsel. And again, this is stuff that happened not just when Judge Penny was up. This is stuff that happened when Judge Getz was still the attorney. So that. In addition, Exhibit B reflects that counsel appointed herein shall have access and authority to review and copy medical records of Britney Spears, the proposed conservatee, with or without his or her consent. There's no statutory authority for this wholesale violation of privacy rights. Ms. Spears was not given 5 days notice of the hearing. Yes, they determined notice was not needed. While it is true that she was a patient at UCLA, she still could have been given notice. On February 1st, 2008, it is not true that there was any medical or financial emergency that warranted the waiver of notice by the court. It seemed again that waiver was to keep Sam Lufty from having knowledge and to keep Britney from potentially fighting back on a more cynical view of it. Spears was reportedly well enough to eat In-N-Out burgers. Everyone's well enough to eat In-N-Out burgers. In-N-Out burgers are delicious. And hospital food at UCLA Medical Center is not that great. And there's an In-N-Out nearby. Anyway, there's also DD Reese nearby, but I could go on. And I will not. Because you're going to see Emily going, oh, I'm hungry. And get totally distracted. No. Just for non-Californians, when you go to In-N-Out, you have to order the fries well done or well done animal style. It's so much better. Also try a Flying Dutchman. They're delicious. Back to this. Do you see? I get distracted. She was well enough to eat In-N-Out, make telephone calls to her father, to her family law attorneys, and eventually to attorney Adam Streisand. We've heard this is the attorney that attempted to remove this to federal court and block this conservatorship, and it did not go well for him. It will be very interesting to hear him speak on this more down the road, and he has spoken some. A minute order, attached as Exhibit C minute order, which is believed to be a correct copy, but was unavailable directly from the court's website. It'll be very interesting. I wonder how they obtained that, but it'll be very interesting to look at when we do a deeper dive into this. We know what a minute order is. Mr. Streisand described during his interview with the New York Times, brilliant documentary framing Britney Spears, that he was fired by Mrs. Spears' counsel by the judge. I don't know how the judge can do that, but the judge, my recollection of the documents is that the judge said you were never properly hired. You couldn't be hired by Britney. So it's not that he was, yes, in practicality, he was terminated, but the judge was like, Britney does not have capacity to hire her own lawyer. So you weren't her lawyer. So you're not here. So get out. And yeeted him from proceedings, essentially. So the minute order affirms that Mr. Streisand was ejected from the proceedings. There is not now statutory authority for a judge to fire a litigant's attorney, but the circumstances are even more bemusing than that. Mr. Streisand also stated that Judge Getz claimed that she had a report, footnote 3, that he was not allowed to see, and setting aside the constitutional violations no one in the room apparently recognized, there was no mention of a doctor's report or a capacity declaration being filed by Mr. Spears' counsel on the case summary. There still isn't mention of a capacity declaration. Footnote 3, Mr. Streisand would later tell CNN reporter Chris Cuomo that Judge Getz told him it was a report from Dr. Spar. The transcript will clarify that point. A thorough investigation should be made by Mrs. Spears' present counsel as to how Judge Getz obtained a report in the first place. Yes, I'm sure that's on the list. Who wrote it and what it said, given the peculiar fact the attorneys for Ms. Spears all wrote detailed declarations regarding their activities for the period between February 1st to 4th. One wrote a declaration regarding attempts to reach Spears' treating doctor, Dr. Long. They wrote declarations memorializing their activities in support of their fees, conversations with Ingham, and even Mr. Streisand. Not a single declaration by any attorney mentions Dr. James Edwards Spar. No one claims to have met with him. No one claims to have spoken to him. No one claims to have obtained a declaration for him. Yeah, it all raises a lot of questions, doesn't it? It goes on to talk about there's no mention of him in the minute order, which is peculiar given that it was written on the purported attorney order attached as Exhibit D. The attorney order is a document prepared by the attorneys for the petitioners. According to the attorney order, once Streisand was out of the way, I like that they add the argument and hyperbole right in there. Once Streisand was out of the way, the attorneys for James Spears, the court, and Ingham agreed to deprive Spears of a copy of the pleadings filed with the court, except for the order appointing Ingham as the for the order appointing Mr. Ingham, Ms. Spears, and Mr. Spears as temporary conservator. This is a rough sentence for me. Mr. Spears as temporary conservator was also authorized to prevent Ms. Spears from seeing attorneys other than Ingham, which, you know, if everything's on the up and up, then why? It all raises good questions. I just don't think that this is going to play in. I think it's, again, more for the public to know this perspective on the beginning of this conservatorship. Since no one's claimed to have contact with Dr. Spar, where did the declaration come from? Certainly there would have had to have been payment made to him. And that's why there should at least be some note of how he was hired, because the conservatorship, I wonder if it's in the first accounting, the conservatorship would have had to approve paying for him and paying for that report at some point. Mr. Streisand was very clear that Spears did not want her father to be appointed conservator of the person of the estate. I think we're all well aware of that at this point. The court violated both the plain language and spirit of CPC 1810, which directs the court should appoint the conservatee's nominee unless the court finds the appointment would not be in the conservatee's best interest. Despite her fame, fortune, beauty, and talent, Ms. Spears was forced to be represented by an attorney she did not choose, who testified against her with respect to that's just duplicated, issues of capacity, and then signed off on orders that violated her right to due process. Soon afterward, Ingham began receiving $10,000 a week for his efforts. The numerous violations of her constitutional rights resulted in an egregious miscarriage of justice, and the court has no option but to terminate the conservatorship promptly and unconditionally. It then gets into that she's been misled by court-appointed fiduciaries. That would mostly be speculation. However, it's not poorly taken speculation. Additional obvious reasons to terminate the conservatorship. Ms. Spears does not now, and in fact has never qualified for a probate conservatorship. There's never been any evidence, much less clear and convincing evidence, that she is unable to provide for herself. They go through all the, there is no reason she should be under this. It's not exactly voluntary the way it says that it is. And then ends with hashtag free Britney. Well, Miss Spears's rancid conservatorship inflicts trauma, exploitation, and abuse. As the court has previously advised, the imposition of this unwarranted conservatorship has brought embarrassment, emotional turmoil, and psychological injury to Spears. It is time for the court to recognize that an egregious miscarriage of justice has occurred and terminate the conservatorship immediately and unconditionally. I don't think that's going to happen on the 29th, but this makes interesting points, and I'm excited to scroll down and see the document that is not unsealed. Ms. Spears has credibly and lucidly articulated what she wants. It's time to allow Ms. Spears to have her life back and be freed of the so-called protection of the Los Angeles County Superior Court. Hashtag free Britney. I just wonder if the way that this is written, the court is going to disregard some of this and just be like, oh, I don't want to hear it. Like, it's the thing with judges. They are still people, and you could see them being like, eh. So let's find that. Let's find that exhibit. It was exhibit B. Here's the citation for conservatorship. This is the order appointing counsel. The court on its own motion appoints Sam Ingham to act as counsel for Britney Spears. Again, that should never have happened. I just don't know if it's going to get undone now. And of course, Sam Ingham wasn't going to undo it. He was getting paid over $500,000 a year throughout the course of this conservatorship. So no, he wasn't going to be the one to be like, I don't think I was properly appointed, Your Honor. This looks like a minute order from February 4th from Judge Getz. See below for appearances. Matters called for hearing continued from February 1st. Jeffrey Wexler, Gerald Cohen, Vivian Thurine appear on behalf of petitioner James Spears. Sam Ingham, court-appointed PVP, which is court-appointed counsel, appears on behalf of Britney Spears. Andrew M. Wallet appears on behalf of himself as co-conservator of the estate. Adam Streisand appears on behalf of Britney Spears. Testimony is taken. Application to seal records regarding the conservatorship of the person is granted as to documents protected under Cal R Court 2.550D under HIPAA as related to medical records. The court record is sealed under HIPAA regarding decisions made related to medical issues. Request to seal financial records will require its own separate motion. Howard Grossman is sworn in and testifies. Proceedings are ordered closed to address the medical issues. Court and counsel address Mr. Streisand's authority to remain during closed proceedings. Mr. Streisand is excluded after being heard. Court finds that Ms. Spears has no capacity to retain Streisand. So this went to a capacity declaration. The thing that's so sketchy about this to me is there was no capacity declaration filed. Ever. There was never a capacity declaration. So how did the court decide that Britney did not have capacity to hire an attorney of her own will when a capacity declaration was never filed? Again, I'm not saying that these things aren't an issue that shouldn't be investigated. I'm just saying at this point, I don't know if this motion will be well taken with regard to the 29th hearing. I think it raises issues that absolutely need to be brought to light. PVP advised his client of today's proceedings and waives her appearance. So Sam Ingham saying, I told Britney she doesn't want to come. He accepted service on her behalf, so she was not served. He requested the court to retain an expert pursuant Evidence Code 730 and suggested Dr. Stephen Marimer is heard and granted. PVP, this is Ingham, shall contact the doctor to ascertain his willingness and availability. He shall file a report by February 13th, if not sooner. Regarding Spears' capacity to participate in conservatorship proceedings, ability to manage her financial affairs, ability to retain and direct counsel, and her susceptibility to undue influence. The report shall address the possibility for psychotropic medication for Spears. The report shall not be made available to anyone without court order except the following: Sam Ingham, counsel for petitioner, Mr. Wallet, and the court, not to Britney. Court makes additional orders related to the appointment of temporary conservator of the estate as more fully reflected. The civil harassment restraining order, that is with regard to Sam Lufty, is modified by the court as agreed by counsel. Temporary letters with additional orders made today are extended till February 14th. This matter is continued. Ms. Spears shall have no contact, direct or indirect, which includes text messaging and emails with Sam Lufty. Proceedings remain closed until concluded. Court makes additional orders as more fully reflected in the official notes of the court reporter incorporated by reference. Counsel for petitioner shall prepare the order extending the letters. And this, again, is what they were saying does not have any reference at all to the doctor's report. So, again, and there's no record of a capacity declaration ever being filed. It was asked for, but there's no record of a capacity declaration ever being filed. And hopefully at some point that question at a minimum will be answered. Like, what in the fuck happened? They were trying to do it. They tried to, but they didn't. So again, I don't know if this motion will be well taken. It definitely lays out what they believe is wrong with the conservatorship, but because this person is an amicus of the court, so outside the court, I don't know how well taken it will be, but it raises all of the questions that others have been raising and raises them directly to the court. Your Honor, WTF with all of this? So we'll see. It's just, Tammy says the doctor at UCLA refused and was advised by a lawyer. I don't think she ever got a capacity declaration. And that again, Judge Penny should have looked into when Judge Penny took the case from Judge Getz. And I don't know if they ever did. I don't know if that was ever reviewed, but we have to move on to other matters of justice. I need to go back and do, like, now that there's more documents unsealed, go back in time and do a little bit of a dive into some of those records with this, because it will help. The 29th is going to be very interesting. And it's just, I don't have words. The whole thing is just so, the beginning of it is so sketchy. It just is. All right, you guys, let's do the YouTube-y things, and we are going to just move on. There is a lot to still cover today. And if we want a deeper dive into this, into the beginning of the conservatorship, I will pull those because I absolutely have them. And the ones that have recently been unsealed and have been going through them slowly, but mess keeps happening in all the other cases that we're covering and things keep getting filed. So it's like the amount of time one has keeps slipping away because, sometimes time slips away. That was a Dave Matthews reference. Let's go ahead and shift over. There is so much regarding these Josh Duggar motions. I'm going to start with the hands and feet one because it seems that that's what I got the most questions about. And then we will get to questions at the end of all of this. So let me make sure I didn't miss any super chats. If I did, you guys, it is a busy day. There's over 4,000 of you on stream. I will absolutely do my best to get to them. I cannot guarantee I will get to everything. I will try. I will do my best. Yes, I still have questions about all of this. So let me make sure I didn't miss anything else and we will shift over. D said, now I'm craving a double cheeseburger animal style and there is no In-N-Out in Idaho. I miss living in California and getting those. I need a double cheeseburger. Hold the lettuce. Don't be front and son. No seeds on the bun. We'd be up in this drive-through. Order for two. I got a craving for a number 9. Like my shoe. I need some chicken up in here in this hizzle. If you guys haven't seen the Big Mac wrap, you haven't been on the members only podcast, but the Big Mac wrap is one of my favorite things on YouTube. It's circa like 2006. It's amazing. Look up the Big Mac wrap. Big Mac. Okay, we need to move on to Josh Duggar, but Daw Mallory asked, it would be interesting to see how the Britney conservatorship changes and how other ones like Amanda Bynes just extended again are handled. Amanda's was just extended again. I have not done a dive into that conservatorship, but I can. On today's episode of the podcast, I actually talk about conservatorships a little bit because with regard to the missing attorney, John Pierce, who I accidentally sometimes call James Pierce because I had a judge that I appeared in front of that was James Pierce. But anyway, I talk about conservatorships. It's crazy. I will talk to you soon about that. All right, I've got to re-timestamp and I got to swoop. We got to do Duggar stuff. We're starting with hands and feet. Are you guys ready to hear about the hands and feet? Are you ready to hear about the hands and feet? Go ahead and share this with anyone who's interested in this stuff. We're going to do the actual legal part of this and get into it. Let's head, shoulders, knees and toes. Anna, in the course of their work, judges in California do have absolute immunity if they are working in the context of their work. So yes, for the things they do in court, yes, they sure do. Josh Duggar. Let's just By way of a warning, the chat knows this. So for anyone who's coming in who's new here, we appreciate you. We do not name call, disparage, wish ill upon people. The justice system will take care of Josh Duggar. We are here to talk about the facts. We are here to talk about what is in these motions, what's going to happen from here, what they say legally, etc. We are not here to, wish that he, fall ill. You can want that in your heart. That is not what we are doing in the chat. I curse a lot. We are talking about or talking around the topic of child sexual abuse images, and we are talking around the topic of CP. Look, I'm going to get demonetized the second I say both of these things. I am going to do my best to talk around the topic for YouTube purposes and not to be triggering to anyone. We are not going to talk about the evidence specifically in this case, but we are going to talk about it because the evidence does come up in this. I'm going to answer some of the speculation that I've seen regarding the hands and feet. But remember, as hard as it is, this is when we practice the facts, not fuckery, and innocent till proven guilty. We're going to talk about the things in this motion that are going to be very hard for his legal team to overcome in court, because we have to still follow process. I value process very much. It's why the Britney Spears thing rubs me so much the wrong way, is a lot of process doesn't seem to have been properly filed. I value process. That is, our law should work the same for everyone. And that only happens if process is followed. When process isn't followed, the law doesn't treat everyone equally. And that is a violation of our constitutional rights. So they have a lot of evidence against him. They will prosecute him to the fullest extent of the law, unless he takes a plea deal, which it seems that so far he's not inclined to do. So with all of those warnings said, and my eternal appreciation for you keeping this chat being the law nerd facts not fuckery place that I appreciate, we are going to get into this. So this is the defense motion with regard to head, shoulders, knees, and toes. I'm making light because it's not a light topic. With regard to hands and feet, defendant's motion to suppress photographs of Duggar's hands and feet while in custody. This is the defense motion that was filed on August 20th. We're going to be going over the government's response. I covered these motions in a separate video, which I will post in the description down below. They talk about the 2-count indictment. When photographs are taken at the time of arrest, these photographs are taken of his hands and feet. The defense is arguing that these were an unlawful search of his person and that these were atypical angles. They're not your normal booking photos. I was saying these are part of booking procedure. We will get into that. They were part of the booking procedure, but Josh Duggar also gave them permission to take these photos, and we'll talk about why. They say that because these were a warrantless search, they must be suppressed. The thing is, they did not ask him to remove clothing and show things that were going to be used in a different way. So for me, I was like, okay, it'll be interesting to see how this goes. I think the defense motion was really well written. It was concise. I didn't know why they were fighting so hard because they also said that this has no evidentiary value in their motion. So if it has no evidentiary value, then why are we fighting so hard to suppress it? Let's get into what the government said about that, because again, this is the one I've seen the most interest in. And so I'm trying to answer the questions that come up the most because I've seen a whole lot of speculation with regard to it. I would like to remind everybody, look, he has been charged with 2 counts. Both of those counts are with regard to possession, not creation, not hands-on types of things. There are different charges for all of those things. Under the Constitution, you cannot charge somebody with one thing and then wait and then later charge them with something else. If you know it at the time, it's called double jeopardy. So if the government had more evidence against Josh Duggar for more things, they would have need to have pled it within this complaint. They didn't do that. That means that what they believe they can prove is the possession, essentially, and receiving it over the internet and then having it from receiving it over the internet. There are other charges for all of the other things. If there was evidence of that, it would have been charged. It's not charged. Once again, if there was evidence, it would be charged. It has not been charged. So that means either there is not evidence or they do not think they can prove it, but they cannot prove it later because double jeopardy attaches. So all of the speculation that the hands might have something to do with hands-on or something to do with other images is not well taken by me. But there are things that these can be used for, and that's the direction I think the government's going in, and we're going to see what they say in this response. After I have a big old sip of water. If you are in Patreon, I'm going to give you guys a picture of this later. I just got in the cups to start sending out, and these are our first round exclusive Law Nerd tumblers, and I freaking am obsessed. I also found this while I was in Vegas. Also obsessed. It does not translate. Ooh, it does not translate well on camera, but it's like almost iridescent-y. Anyway, fabulous. All right, let us move on. The government's response. United States response in opposition to defendant's motion to suppress photograph of defendant's head, shoulders, knees, and toes. This is why I pull it up so you know when I'm joking. It says hands and feet. For those of you audio only, it says hand and feet. On April 28th, the grand jury returned a 2-count indictment, possession of CP, and receipt of CP. Defendant was arrested the following day. While defendant was being processed as he was taken into custody, while he was being booked into custody, a special agent with DHS, HSI, asked defendant if he could photograph defendant's hand. Defendant expressly consented to having the photographs taken. At no time during this process did the special agent or any other law enforcement officers involved in the processing a defendant raise their voice at him, intimidate him, verbally or physically threaten him. It was like, hey, can we get a picture of your hands? Yeah, okay, stand like this. The photographs document a scar on defendant's hand, which is plainly visible. Again, plainly visible when they're booking. No search warrant needed is their argument. Law enforcement observed the same scar and images recovered from the defendant's electronic devices seized pursuant to the search warrant in the case. So they looked at it and went, hey, we recognize that scar. Now, I looked at these photos. Maybe y'all see it and I don't. But I looked at these photos and did not see exactly what they were talking about. It's probably more obvious when it's larger. It's probably more obvious to law enforcement because they know what they're looking for. I don't know what they're looking for. And I don't know if the scar's somewhere that has been clipped off. I don't know if these are the full images that were put in the motion. So I don't know what scar they're talking about. I don't know if it's this. It's hard to tell on these reproductions of the, I don't know, could it be that? I don't know. I don't know what it is. Maybe this blip of a scar right here. I don't know. So they are talking about, or the government's talking about, a scar on his hand that is consistent with photos found on the phone. Now, why does this matter? Because they're using the phone to show that he was at the car lot when the images were downloaded. They know when this happened. They know when the images were downloaded, and they're tying together that evidence. Remember, with computer crimes, you have to prove who was at the keyboard. You have to know who was there. You have to know whose phone it is. You have to prove it's their phone. So saying, look, this is his phone. This is his password. This is the IP. This is the photos. Look, there are photos of him in here of his hands. That's his hands. How do we know? Well, this hand has a scar. That hand has a scar. And you're not going to show it in court. You're going to blow it up on the big screen so the jury can see it and be like, see, this is how we're proving this device is his. This device is used by him. And this is also how we're proving that he was the one at the computer and no one else. And that's alluded to in some of these other documents as well, because what his defense team is going to argue is that it wasn't him at the computer. Anyone could have accessed that computer. How do you know he was the one that received it over the wires? How do you know he was the one that possessed it on his computer? we'll get to that in other motions. But that's what the hands tie to. That how do you know who's holding the phone and doing the things? And they're using photos that are geolocating him at the same time. They're using metadata that are geolocating him to the car lot at the same time. And in later motions, watch me say I'll talk about it later and then talk about it now. Of course. In later motions, they talk about the fact that there were no other employees of the car lot at this time. No one was receiving payroll at the car lot except for him during the time when these images were downloaded onto the computer at work, according to the government documents. So let's continue. He consented to it being taken. Their argument is that law enforcement's photographing of his hand. The defendant's argument is that the photographing of his hands was a warrantless search in violation of the Fourth Amendment, that the photographing was a Fifth Amendment violation for unspecified reasons, and it was a Sixth Amendment violation of his right to counsel. No. He said, yes, you can photograph it. They said it doesn't fall under the search and seizure of the Fourth Amendment. It doesn't fall under Fifth Amendment. It doesn't right against self-incrimination because it's just a physical attribute. And it doesn't fall under Sixth Amendment because he didn't have a right to counsel during booking procedures. It's not a relevant part of the booking of the criminal proceedings where he would need to have a attorney. This is a plainly visible. He was not ordered to remove clothing. He was not ordered to have things that were going to be clearly, look, like in gang cases, when people have gang tattoos that are on their body, those tattoos are used against them. You generally have a warrant to remove the shirt, take photos of those tattoos to say, look, in this particular gang, the only people who have these tattoos are other gang members, and you're using it to prove their guilt in a different way than saying, look, we're using this to prove not guilt. We're using this to prove that this phone belongs to this person and that this phone was at this location at this time and that it belongs to this person. Therefore, that person was there at this place and time. So a bit of a different argument, if that makes sense. They say that it was not a search and that the case law agrees that it was not a search, that the Fifth Amendment rights against self-incrimination were not violated. I agree with that. That the Sixth Amendment rights were not violated. They don't argue it much. They say the right to counsel only attaches at critical stages of criminal proceedings, like being interviewed. Taking photographs is not a critical stage. This was essentially a booking procedure, and that's the end. So no, I don't think they are trying to say that there is more going on with his hands. I honestly think it's just tying place and time to tie together all of the evidence to know that what was on the computer was done by him. So that is what I believe they are using this for here. Again, there aren't other charges against him. If other charges come up, then that would be different. But this is to tie him to this. Cher, I've seen this question a lot. He would have been charged with that. He's not charged with that. The images that he had on his computer are historical images that are well known to law enforcement. So the images he is charged with based on the other motions by law enforcement are known and long ago created, if that makes sense. Let's get into the motion to suppress the statements, because there is a lot with regard to his statements at the time of arrest. I thought this was an interesting argument. I said when I read the defense motion that the motion was well done, but it wasn't going to fly. Same assessment. The motion's well done on the behalf of the defense attorneys, but it's not going to fly. So the statements aren't going to get suppressed. But let's find out more about what he said, shall we? Let's find out a bit more. Because the statements before they even started recording are the ones that are going to do it. So, summary of the argument. I really appreciate the way the AUSAs wrote these briefs. The lawyering in this has really been fantastic. Even though I don't agree with the defense positions, I think they have done a very good job of presenting their positions and going after everything possible. Because when the evidence isn't in your favor, You have to try to get rid of as much of the evidence as possible. I don't think that's going to happen. I also wonder if when these motions, the defense motions get denied, which I think all of them will, if when those motions get denied, if there will be a shift in his decision to maybe take a plea or not. That could happen. They could be waiting to see this being they could wait to see this play out with the court. So, suppressed statements. These are statements given by Duggar to the police. At present, defense asked the court to suppress all statements made by Duggar after he asserted his right to counsel and after federal agents physically stopped him from communicating with his attorney. You guys remember these facts. The agents showed up to serve a warrant. Duggar pulled out his phone and said something like, I want to call my lawyer. And they said, yeah, that's great, but this is subject to the search warrant. So we're going to go ahead and put this away safely. Thank you so much. In an investigation like this, when we are dealing with digital evidence, people can delete digital evidence from their phones. They can wipe their phones. People who are quite savvy have like kill switches for digital evidence where everything can be wiped. So the second he removes his phone from the pocket when agents are there, I'm not surprised that they took it. I would not expect anything less. I don't know if Duggar is that savvy, and I'm not saying that he is. I'm just saying that that's the context law enforcement's coming at this with, that you can't keep your phone and be like, delete, 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 delete. delete. And I've told stories about different clever ways people have gone about doing that in the cases that I have either worked or the cases I've been trained on and discussed with law enforcement. So let us continue. The government argues he was never in custody for purposes of Miranda. I agree. So they're saying his right to counsel never attached. In either way, he didn't assert his right to counsel. Moreover, his request to call a lawyer was in response to the announced search warrant, not an invocation of his right to have an attorney present during the interrogation. Finally, after being informed of his rights to counsel and to remain silent, he knowingly and voluntarily waived his rights in favor of making a statement. Duggar's motion is without merit and should be denied. I think it will be. The United States investigation on November 4th, they got a federal search warrant based on probable cause about the IP address used at wholesale motor cars located in Arkansas. They downloaded that IP address downloaded or possessed images of CP. Agents did not obtain an arrest warrant at that time, which is notable because they weren't arresting him. They did not arrest him until after the grand jury. They were just going there to seize evidence because at that time, generally it's like, hey, these computers are doing this thing. That's the first phase. Then as investigators, it's their job to go, okay, who's using these computers? Not to have a preconceived notion of who's using these computers, but to follow the evidence itself in a scientific way to determine who had those. Not go, oh, I think this person's doing it. Let's build the evidence around it. It works the other way. These computers did the thing. Now let's figure it out. On November 8th at 3 p.m., they executed a search warrant at wholesale motor cars. They described the driveway. They did a soft approach on the warrant. They were in plain clothes, not tactical gear, which means they were in jeans and shirts and stuff, normally with a vest that says, and they said they had a protective vest that says police or Homeland Security. If you want to see what that looks like when they're in plain clothes with those vests, go watch the first 2 minutes of Real Housewives of Salt Lake City because Homeland Security showed up to arrest Jen Shaw. And we started seeing footage of it. That's what they mean by plain clothes and vests. They approached the defendant and two other individuals who were there. The lead agents exited their vehicle, notified Duggar that they were there to execute a federal search warrant, that it was a search for items containing digital contraband. It was not an arrest warrant. Then neither him nor the individuals were under arrest. They were free to leave. Like at that point, they would have asked for his phone. If he had gotten in a car and left, it would have been fine. Directly thereafter, defendant took out of his pocket a cellular phone, Apple iPhone, stated he'd like to call his lawyer. In response, Faulkner, the agent, explained that the defendant that his device was covered by the warrant and was being seized pursuant to the warrant. Faulkner then, using just one hand, took the phone out of Duggar's hand. Again, yeah, we have a warrant for that, thanks. With minimal or no physical contact with Duggar. Shortly thereafter, Duggar informed law enforcement that he might have to leave because his wife is pregnant and due to give birth at any moment. Faulkner acknowledged such and reaffirmed that he was free to leave. It's like, yeah, do what you need to do. We're here. Duggar chose to remain on the lot. After securing the premises and starting the search warrant, the agents asked if he would be willing to discuss the details of the search warrant, and defendant agreed. Due to the ongoing search, the agents indicated that they could speak in the vehicle. Again, Duggar agreed to speak with them. Of note, while speaking with Duggar outside the vehicles, the agents did not have any firearms brandished, nor did they physically direct or escort the defendant to the vehicle. So they weren't saying, get in the car. They were saying, hey, do you want to chat with us? Yeah, okay, we should sit in the car. They're doing the search warrant. We need to just have a chit chat. Faulkner went to the driver's side front door. The other agent went to seat in the driver's side rear door. And then Duggar walked to the front passenger and opened the door and entered. At no time did law enforcement officers stand outside, block, or guard the door, and the doors to the vehicle were not locked. This is all going to, hey, he's not in custody. If he wanted to open the door and walk, he could open the door and walk. If he wanted to not talk to them, he could say, I'm not talking to you. Come back to me if you want to put me in custody. I don't want to talk to you. He had that choice. But like most, I think curiosity got the best of Josh Duggar, and he wanted to know what was going on and thought that having a conversation with them, he would learn more than they would. By the way, that generally doesn't happen. If you think you're going to learn more from law enforcement than they're going to learn from you in a situation like this, you are wrong. Just that's how that works. Immediately after Duggar entered the vehicle, they asked the defendant for his consent to record the conversation. He provided it. Always a good thing because it protects everyone, protects law enforcement. It protects the person speaking. You said what you said. It's recorded. There's no confusion. After consenting to the recording, but before they could initiate recording, defendant turned in his seat and asked, what is this about? Has someone been downloading CP? It's a very strange question to ask. Law enforcement will bring this up at trial. The prosecutors will bring this up at trial. This is not a question one normally asks. It indicates to me as a former prosecutor that he knew exactly why they were there. How do you know exactly why they're there? How would you know? How would you know unless you knew what was happening on your computer? How would you know? How would you know that's why they're there? And it's a car lot. It's a used car lot. Why wouldn't you assume it's financial related? Because taking all of the devices could easily be related to financial crimes. But that's not what he said. That's not what he said. What he said is, what is this about? What they're alleging, he said, was, what is this about? Has someone been downloading CP? Okay. At that point, they told the defendant to not ask any further questions until they started recording. It's like, dude, shh, put a pin in it. We have not started recording yet. So, yep. You've got two officers that have, at the detention hearing, this came up too. And under sworn officer testimony, that's what they said. So then it gets into his statements of rights, and they're giving him his Miranda rights. What's very interesting is they say, again, this is a search warrant. This is not an arrest warrant. You're free to leave. And the form that they used had a bit about custody. And Duggar's like, hey, if you say I'm free to leave, why does this say something about being in custody? Can we cross it out? And they said, yeah, we can cross it out. So he talked to them about it more and confirmed again that he was not in custody and actually advocated for himself in crossing that part out of the signed waivers, and did in fact cross it out of the signed waivers. So he was actively engaged in reading and understanding what was being said and what the rights were, and making sure that it reflected the conversation, which again is going to play to denying this motion because he was very active and aware. Thereafter, Duggar signed the form acknowledging that he was voluntarily agreeing to make a statement. Duggar confirmed that there's internet service at the dealership, including Wi-Fi. Duggar identified his personal cell phone as an iPhone 11 that he purchased 2 to 3 months prior. The cell phone has a passcode. He declined to provide it. Well, he knew they couldn't get him to do that. Duggar stated he owns a password-protected laptop located in an RV on the dealership. He also stated that he owns a password-protected HP computer located in the main office. He said that the dealership employees use the computer. In a later motion, the dealership employees say that they don't necessarily use the computer. So Duggar stated that he's familiar with file sharing programs and torrent files, but declined to get into specifics about his knowledge of those programs. Well, you've said enough once you said you're familiar with them, in my opinion, but okay. He did state that his laptop, cell phone, and computer desktop may have peer-to-peer file sharing programs installed on them. Duggar also stated that Tor is on one device. Up until this point, law enforcement had no knowledge that Tor, which is abbreviated for the Onion Router, and is an online network designed to provide users with anonymous access to the internet, sometimes referred to as the dark web, was at issue in this investigation. So they didn't have what they had at this point with their warrant was the IP address and the hashed files going to that IP address. They located the IP address by going through the company that was providing internet to that location. Look, we're the internet service provider. This IP goes to this location. But they didn't have the devices yet. So they didn't know that the device was using Tor until he offered that up. So again, he's offering them more information than they would otherwise have, indicating he is well aware of what's on the computer. Here's what's interesting. At the detention hearing that was hours and hours long, they talk about the fact that his computer was partitioned. It was split. The hard drives are split, like two different computers. And on one partition, he had this program called Covenant Eyes that logs what you do on the computer and particularly is marketed to help with adult explicit image addiction and things like that. And you have a buddy and they get sent a log of your internet behavior. His wife was on the other end of that Covenant Eyes program. So if he was searching the web for anything that would trigger the program, his wife would get a log of his internet activity. That comes up later, but he also had a second partition of the computer. The second partition, they said in the detention hearing, used a similar password as his social media accounts and bank accounts. If your bank account uses the password, what is the probability that your employees have that password? Everything that was found was on the partitioned side of the computer. I am going to guess, this is a speculation, that Tor is not on the business side of the computer, that Tor was on the other partition side that didn't have the Covenant Eyes program, that wasn't logging what the fuck he did on the internet. It was on the sneaky side of the computer. And if your sneaky side of the computer uses your same password that you're using for your bank account, are you giving that password to anyone? And these are the things that the prosecutors are going to ask the jury to ponder. And the jury's going to go, I don't give my bank account password to fucking anybody except my spouse. So let's continue on. There's so much here. After being informed that the investigation involved CSAM being downloaded at the car lot, Duggar inquired whether something had been downloaded on one of his devices. Who, my devices? Was it on my devices? How would they know? He then inquired whether the IP address for the lot was marked and inquired about the scope of the search warrant. In the chat, if you know what it means to have your IP address marked, I'm going to do a poll. We're going to ask y'all if you know what it means to have your IP address marked. Because I am super curious. So let me do a poll real quick. It won't let me do a poll. Why won't it let me do a poll? It's not letting me do a poll. It's mad at me. Give me a second. I really want to do a poll. Actually, you know what? If it's going to take me too long to figure it out because it's now being mad at me. Oh, darn it. I'm going to shut this poll. Hold on and do another one because I wanted to ask the question and we'll ask it. I'm also going to put our chat on slow mode because God love our moderators. I forgot to do it. And there are like 5,000 of us in here. So I'm sorry. We have to go to slow mode for ease of me. And I'm going to try to do a poll real quick. All right, let's see if it'll let me do it. Yay, this is riveting. The polls are anonymous, by the way. That's the only reason I ask. I would never ask anything incriminating. So I put up a new poll. Go ahead and vote. It's up. And let's get back into this. So again, you're never going to get more information out of law enforcement than they're going to get out of you. Not guess, not guess. Do you know? Do you know? And Charlene, that's a very, very good reason to answer yes. You are few and far between. So he inquired whether the IP address was marked and inquired about the scope of the search warrant. Once we finish the poll, I'll come back to why that matters for prosecutors. Duggar later indicated that to his knowledge, nothing was downloaded or uploaded from any computer on site that would raise a red flag for the investigation. Why does he know what raises flags? Why? Why do you know? He also stated that he was not denying guilt. I would love to hear the audio of this. The jury will get to. But he was not going to say anything to incriminate himself. Too late, buddy. Asking if your IP address was marked starts with it. Asking them if they were there because someone was downloading CP starts with it. You have already said incriminating shit. When asked directly if he had seen images of CP involving children ages 5 to 10 years old, he said, "I'd rather not answer that question." Prosecutors cannot comment or draw inferences from someone who chooses to take the fifth. Prosecutors cannot say things like, well, an innocent person would testify, sit up here in court and tell you. Wouldn't someone who's innocent do that? No, you cannot comment on somebody's right against self-incrimination. You know what you can comment on? Shit that people said. Do you know what he said? I'd rather not answer that question. Okay, buddy. Sure. I bet you don't want to answer that question. Have a real long chat with your lawyer about whatever the government's offering you, because this is not going to play well before a jury. Because you know what a jury's going to say? A jury's going to say, I don't know what the fuck it means to have my IP address marked. Why do you know what that means? What kind of dark web bullshit are you doing that you would even know what that means? That's not coming up on true crime shows. The interview concluded and Duggar left before the search of the premises was complete. See, he was so free to go that he actually went. He was so free to go that he left. Law enforcement did not arrest anyone that day in connection with the search. And they go on to say that the statements were voluntary to law enforcement. They are. Duggar asserts that the conversation was a product of an egregious and inexcusable violation of his constitutional rights. It wasn't. The court's going to deny that. They go through the custody elements. He wasn't in custody. Defendant was not in custody until November 8th. When Duggar was informed he was free to leave or not under arrest, he actually did leave. He elected not to leave until after the interview, and then he left. Approximately 2 minutes and 30 seconds into the interview, while reading his Miranda rights, he asked the agents about the line on the form regarding him being taken into custody. And then they let him line it out. That's all going to, in the court's mind, go, oh, he was comfortable enough to say, hey, I'm not in custody. It says I'm not in custody. Line it out. That right there shows that he was well aware that he was not in custody. And they said, to be clear, agents did not confiscate his keys nor stop him from leaving the lot. In fact, given that it was his car lot, he had lots of vehicles at his disposal. They scratched it out. He was unrestrained from movement. And then the defense argues that he was not provided a complete copy of the search warrant until when the search was completed. The government points out that the defense failed to realize that at the conclusion of the interview, Duggar did leave the premises and instructed law enforcement to leave the return with the employee. So at the end of the search warrant, they left the search warrant like receipt, essentially, with an employee. So he left before they finished the search, again proving that he was, in fact, say it with me, free to leave. Free to leave. All right, I'm going to finish up this and then I'm going to close the poll out. So go ahead and vote. There's no question to me that he was free to leave, that he was not in custody. They go through the different elements of that. They didn't use deceptive tactics. They were upfront with him. And so they went through all of the different legal analyses. You will see how many times they say Miranda in this thing. It's a lot. I'm not deep diving into the legal analysis. I agree with the legal analysis of the government. And I said it when I read the defense motion that he's probably not going to be considered in custody for the purpose of that interview. And therefore, it won't be suppressed. I don't think this motion's not going to be granted. I would be shocked if it were. So that's with regard to the motion to suppress all the statements. I can see why they want his statements suppressed. I can absolutely see why they want his statements suppressed. Everything he said to the government or to the officers, they want out. They don't want it coming in that he said, hey, is somebody downloading CP? Is that why you're here? Because of course that's your first thought when federal agents show up. No, it's not. I'd be interested to hear what people who really study psychology would have to say about that, because it seems like it just kind of popped right to the forefront of his mind. So they also really laid out that he asked about that flagged IP address. So let's close out this poll and see what you guys said. We're going to end the poll and see what it says on those poll results, which I love. So, do you know what it means to have your IP address marked? No, 81%. Yes, 18% with over 1,000 votes. Thank y'all. So, here's the thing. When there are, without being instructive, when there are IP addresses that have shit going on, law enforcement can flag them or mark them to follow up with what they're doing. And he's asking if his IP address had been marked. I think the only way you would know that is if you're talking to other people who are doing things on the internet that maybe they don't want detected. And so they're talking about the different ways these things get detected. You'd be amazed at how much conversation there is within groups that try to evade law enforcement. And you'll hear it on wiretaps if you're doing wiretaps for certain types of crimes. You will hear it in jail calls. You will hear this information passed along. There is definitely a collaborative effort in evading law enforcement in different communities of criminality. So it seems to me that those conversations had been had by Duggar and others because he knew to ask the questions that others wouldn't know to ask. Most people wouldn't put a Tor or wouldn't put Tor on their computers. Most people don't want access to the dark web because information on the dark web goes both ways. And if once the dark web is the epitome of fuck around and find out. If you try to fuck around on the dark web and don't know what you're doing, you are going to end up just getting fucked. Like it is not. It is. There is a great series called Dark Web that Audible did under Audible Originals that is very, very interesting. Also, if you haven't listened to Ghost in the Wires to talk about the different processes of hacking and stuff, it's a fascinating book about the early days of hacking. But the Dark Web series on Audible Originals, I cannot recommend enough. It really is fantastic. It's dark. Just be aware. Dark shit happens on the dark web. It's aptly named to give you a warning. All right, I'm going to do appointments clause last. Let me get to this next one. There are several more of these to go. This is with regard to, I'm trying to do the ones that have the most interesting information we don't know and aren't just straight up legal documents or legal arguments. The next one's with regard to the motion to suppress in the Franks hearing with regard to the search warrants. He and his legal team are trying to have the search warrants suppressed in their entirety, because if you suppress the search warrants, you suppress everything that is gleaned from the search warrants. So, Raina, yes, I should have just put a NordVPN ad right into this, right into today. And this is a fantastic point, Dora. Exactly. If you ask the question about having a marked IP, you're aware that you're doing shady shit. That will be what the prosecutors argue. That's exactly what the prosecutors will argue. It's very interesting. when people say things that's incriminating that they don't realize are incriminating. And I think that's what happened to Josh Duggar. A lot of people think that they are smarter than law enforcement, and they don't realize how prosecutors will helpfully point out the things that they say and say, look, see, why would you have that knowledge? Why would you say that if you don't know? Valerie, yes, The Dark Web on Audible is a 10-episode series. It's amazing. If you are not sponsored, but should be one day, I love Audible. But if you have an Audible subscription, you should have access to all the Audible originals. So this is going to get into them trying to suppress the search warrants, because if the search warrants are suppressed, then you suppress everything. So, summary of the argument. John Adams once argued that facts are stubborn things. John Adams, OG facts, not fuckery. Facts are stubborn things, and whatever may be our wishes, they cannot alter the state of facts and evidence. John Adams, cheers. I feel you on that. This admonishment is telling in the present case, as the defendant challenges the validity of the search warrant authorized by then Chief U.S. Magistrate Judge Aaron L. Whiteman, and in doing so directly asserts that the affiant of the warrant, HSI agent Faulkner, intentionally misled the magistrate. However, facts are stubborn things. A simple review of the affidavit at issue reveals that there was probable cause supporting the magistrate's issuance of the warrant, and the defendant's claims that Faulkner misled the magistrate. The inflammatory yet baseless claims fail owing to an examination of the facts. A faulty and underdeveloped opinion by the defense's expert and a review of the applicable law. As such, the defendant's motion to suppress and for a Franks hearing should be denied, as it's utterly without merit. Oh, man. So let's get into it. This is talking, I'm going to summarize the best that I can. One of the most interesting arguments by the defense was that there was a reasonable expectation of privacy in the internet behavior because of the Tor browsers. So the argument being, somebody went to such lengths to protect their internet activity. Therefore, they had a reasonable expectation of privacy in that activity. Therefore, the government kind of trampled that expectation of privacy, and the search warrants should be suppressed because the government is using this other program, and this program is essentially casting a fishing net into the interwebs, pulling out information, but they can't do that. They can't run that program, that net that they're casting on the internet. They can't cast that net without a warrant. And because they were casting that net without a warrant, and that's where they grabbed the information and saw, these things, these hashed files that contain known CP, were going into this IP address. So we need to go investigate what the fuck's happening over there. What they're arguing is that initial part, that initial net needed a search warrant, but that initial net doesn't have a search warrant. That initial net is just like, hey, we can grab things off the internet because the internet's not private. When you do shit on the internet, you don't have an expectation of privacy. Ask anyone who's had their DMs screenshotted and shared. There's no expectation of privacy when you send information out into the great wide open. Into the great wide open. So that's kind of the heart of the argument. But we were trying to be sneaky, and the government was being more sneaky. I really, really didn't want people to know what I was up to. Therefore, I thought it was private. Nope. All right. We're going to nope out on this real quick and talk about the government's program. The activities of defendant Duggar came to law enforcement's attention in May 2019. Why is we're supposed to be on Do Not Disturb. Now we're on Do Not Disturb. Why am I getting case notifications? What happened? Oh, antitrust. Okay, we'll get into that later. All right. I'm back. This is why I put my phone on Do Not Disturb, because it does, in fact, disturb me. Detective Calmer of Little Rock PD was conducting undercover online investigation on the BitTorrent peer-to-peer file sharing network utilizing torrential downpour program. I think it's a hilarious. I love it. I love the way law enforcement names things. There's always a cheekiness, like Operation Varsity Blues. There's always a cheekiness to the naming, and I appreciate it. I also appreciate that there are like 4,500 of you watching. Thank you, and do the likey, subscribey things. So law enforcement uses torrential downpour to essentially fish the internet for these known hashed files and pull them in and then go, where were you going? Damn it with the songs today. But they're like tracking this one little hash and going, where are you going with your long face? Fallen down, and then they pull those in and then track them to what IP addresses they're going to, and that's how they start their investigation. And then once they find the IP address, then they get search warrants to go and get the physical devices to try to continue to track it. Torrential Downpour is a law enforcement software program configured to search BitTorrent network for IP addresses associated with individuals offering to share or possess files known to law enforcement to contain images or videos of CP. So once again, these are known files that get shared around and around and around. During the investigation, she observed that a user connected from the IP address, the target IP address, and was sharing CSAM over the network using the torrential downpour software. The detective downloaded the images directly from this user. The files include, and these are the files that we're going to not get into graphic detail about. One of them is 65 viewable images, a zip file. That's the marissa.zip file. We're not going to get into what that is. Don't Google if you wish to remain innocent to how dark the fucking dark web is. I'm just, as a word of advisement, you may think you want to know. You don't. You don't want to know. If you think it's bad, add like 100 to that and just go, oh, so bad, and then add some more to it. Don't just I can't tell you what to do. You're adults. I'm just suggesting. Curiosity will forever scar you in this. So they we're going to move on from the description of the files. It describes the files enough that those files would warrant a search warrant. After downloading the files, the detective determined the target IP address was geolocated in Northwest Arkansas, NWA, the other type of NWA. They contacted Faulkner, who investigates federal CP offenses in Northwest Arkansas, to inquire if he would further investigate the user of the target IP. That's how they started their investigation. They went and found where it was using Ozarks Go. They found a different address, and then they found the correct address. The correct address was the car lot. There was an issue with, was it here or was it there? They returned the search warrant. They fixed it. That happens. There's nothing shady or sketchy about it. It was from the internet company. They were able to rectify it, and they will treat it, in court. They will talk about, hey, this is how we determine where the IP went. This is how we determined that we got the wrong address at first. This is the search warrant return. This is how we determined it was the right address. This is what we confirmed with Ozarks Go. When they go to trial, they will have the head of IT from that company come in and testify about all of that as well. It won't just be the agents. It will be the underlying people as well. So, Kaylin Ann makes an excellent point that the security team at Google has a therapist on their team. There is a reason. You can't unsee and you can't unknow. Because once you know, you cannot unknow. Let's continue on. After confirming that Duggar operated a car lot on the adjacent property and confirming with Ozarks Go the correct address related to the subscriber associated with the target IP address at issue, they sought the federal search warrant for the car lot from the magistrate judge. In the affidavit to support the search warrant, they stated the relevant facts that in May 2019, 2 separate downloaded files were successfully obtained from IP address. One of the download files was a zip folder containing 65 images and a video. The other one was a video. He reviewed the 2 files successfully downloaded and talked about what they contained. Again, this is the sanitized version. You still don't want to know. Additionally, Faulkner states at the search warrant affidavit that approximately 93 files of interest connected to the IP address had been flagged by law enforcement as potential CSAM. Yeah. As for referencing the initial search warrant, Faulkner details for the judge who approved the warrant and the mistaken address just days prior, what steps they took to correct it. So again, it happens, not an issue. They talk about issuing the warrant and what they took. They took the iPhone, they took a MacBook, they took the work computer. They talk about the forensics of the devices seized. They talk about what they did with the forensics and how they went about doing the forensics and getting the forensics. This is talking about the Linux partition. The Linux partition is the partition when I talked about partitioning the computer. So one part was like the clean part with the covenant eyes, and the other part was the like not. The Linux partition is the part that's like not. Both HSI and HTIU's examinations revealed that the Ubuntu Linux operating system had been installed on the device on May 13th, 2019. The Linux which means it was in existence at the time of the downloads. The Linux operating system created a password protected partition on the device's hard drive separate from the Windows operating system that came with the device. The password access on the Windows operating system on the HP desktop is Joshua JJD. Well, that was the password for the Windows side. Well, the password to the access the Linux partition is, and they blurred it out, 1988. Why did they blur it out? Because 88 is Duggar's birth year. The password is intentionally redacted because it's the password for other things, including bank accounts and social media accounts, and they're not sharing that. Overall, both forensics examinations revealed that the Tor browser and separately the BitTorrent client uTorrent have been installed on the Linux partition on or about May 13th and May 14th, 2019. Thereafter, the forensic evidence supports that both programs were utilized to download and view CSAM. Of note, both forensic examiners located images, and they had it done by both Homeland Security and by their other by two different departments. So this computer went through two of the browsers or two of the forensic evaluations. So that showing that the Marissa zip file referenced in the warrant was factually downloaded via the BitTorrent peer-to-peer network on May 15th. Defense expert Bush was provided access to a forensic copy of the HP computer itself that contained said files prior to submitting her affidavit, in which she claims the images allegedly possessed by the remote client were in such an incomplete state that no user could view the images. The existence of these images is likewise memorialized in the forensic reports. So the defense is saying they weren't viewable. They weren't in a viewable format. And they're saying, no, we had two different forensic evaluations confirm it. So let's continue on with that. They talk about the MacBook being examined, the forensic image of the hard drive contained therein was created on November 12th. Thereafter, all review and analysis were conducted on the forensic image of the hard drive. So imaging the hard drives mean they made an exact copy of it and then went about tinkering with it so that the original was preserved in its original state. So you can't say, oh, this was manipulated by law enforcement. No, we only did the forensic evaluations on the imaged drive. It's a direct copy, an exact copy. And we worked with the copied one, not with the original one. So from the MacBook, law enforcement determined that Duggar had backed up and synced his iPhone with the device. On the MacBook, law enforcement located numerous pictures and text messages. We talked about this earlier. That placed Duggar at the car lot while the CSAM was downloaded, accessed, and viewed on the HP computer. So they used what he was doing on his phone to geolocate him at the location with the computer at the car lot at the time this happened. And then they're going to be like, oh, and the password is this. Oh, and the password is used here and here and here. That is how they are going to tie this evidence together to prove who is at the keyboard doing this. This evidence was all memorialized in the report of investigation submitted in April 2020. HSI discovered during its examination that Duggar used the password redacted with birth year or close variations for multiple online accounts, including his bank account and social media accounts. The bank account one is like, for the prosecutor, the bank account one is like, yeah, How does anyone have that access to that? That is going to be what prosecutors will hit on, because jurors will understand. Jurors will sit there in their juror brains and be like, yeah, I don't give my bank account password to anyone. And yeah, I might use the same password for certain things, but if I use the same password for multiple accounts, I sure don't give it to anybody. The iPhone 11 was forensically processed because Duggar didn't provide the passcode. Law enforcement only achieved a partial extraction in November 2019. They talk about that. But in the partial extraction, they found the same images and text messages consistent with the backup on the MacBook and the same password. They go through all of what the BitTorrent network and torrential downpour is, how it works, why you don't need a warrant for it, et cetera, et cetera. They talk about the case law saying that law enforcement's allowed to do this way. Defendant does not have a reasonable expectation in privacy in his IP address nor files that he shared with third parties on peer-to-peer networks. Duh. Right. Just because you're trying to be sneaky doesn't mean you have an expectation of privacy, even if you'd like it to be so. Not legally speaking. You might have an expectation that like your wife won't see it because you've partitioned, but you don't have an expectation of privacy that no one's ever going to see what you do on the internet. Especially when you're routing through an internet service provider. You're routing through other things and connecting to another end. So the search warrant was supported by probable cause. And then they go through the rest of the law supporting that the search warrant was legally obtained. And then they go through all of the search warrants and connect them. So this is 212 pages long. They talk about all of how they did the forensic examination, what they did, and then they attach all of the search warrants for the judge to go through and look at, and all of the case law that supports it. I think they probably didn't need, they did a lot. But again, this is a big one. If they lose this one, they lose everything. So this is a big motion for the government. They did the most in responding to this, and they attached all of the search warrants. Again, we're at the end of the motion at page 41. This is 41 out of 212. We're not going through all of these search warrants, but they are here, all of them. The original search warrant and return, the corrected search warrant and return, the photos. Here, we'll pull up. We love pictures all the time. Just attach pictures to everything. It makes it easier. So let me scroll and pull up the photos of the car lot when they went for that second search. So everybody just has a visual of what we're talking about. Well, a visual of the search warrant and where they were searching, not of anything else. No other visuals in this case are needed. This also has a lot of IP addresses in it, and I have not had time to go out and redact all of those. The subject IP address is already out there, and I'm sure that's already been shut down. I don't know about the other ones, so abundance of caution. Also, yes, they are public record, but I don't have to share it on the internet. So this is them with how they got to the address, what they're searching, what structures they're searching, where they see it, what the office is, where they're getting the computer from, that stuff. So that's what they're using. Items to be searched and seized. They list all of those out, and then go into the affidavit of what they know and how they know it, which is a lot of what we've already talked about. All right, so now we need to get to the motion regarding the failure to preserve evidence. Also, don't forget to do the likey, subscribey things. Failure to preserve evidence. This relates to the defense motion that other people were questioned and their cell phones were not forensically examined and were not captured. There were not mirrored drives made of them. So the defense can't evaluate them, and those might have information that's exculpative or information that can prove that he, or to prove at least that there's a reasonable doubt that it was him and that he was the one who was downloading images. And without those phones, they can't have a defense, and therefore the government should have preserved those. The government's in some arguing, nuh-uh, we don't have those. We didn't see any evidence of those. We're not using those. And so we don't have a duty to turn over or preserve what's not in our possession. So let's get into the United States response in opposition to defendant's motion to dismiss for failure to preserve potentially exculpatory evidence. This one has some very interesting information because it tells us what others have said because there are other witnesses. Yes. Okay. We know the background, but where the background is new. When law enforcement arrives at the premises, they found defendant who owned the dealership since 2018 and two other individuals. Law enforcement determined one of those individuals, identified as witness 3, worked at the car lot and interviewed him. The individual told law enforcement that he began working at the defendant's car lot in June 2019, did not access the internet at work, and that the computer in the office on the car lot belonged to and was only used by defendant. Wah, wah. It's going to be really hard to say someone else wandered in and went to my computer and used it. It's going to be really hard when the other people that had access to it come in and say, I didn't do that shit. Real hard to argue. Let's look at the footnote. According to records obtained from the defendant's business, this individual received his first paycheck from the defendant on May 31st, 2019. There are no records of payment to any employees who worked at the dealership on May 14th or May 15th when the user of the lot's IP address was sharing CSAM over BitTorrent peer-to-peer network. So there are no payroll records for anyone until the end of May after the images were accessed. So who was working there? Who was working there that accessed the computer then, Duggar? I have questions. Because nobody was on payroll. No one was on payroll. Yes, I have been abbreviate them, but they are child sexual abuse material. So I abbreviate that to either CSAM, which is hard for me to say, or to CP because it is easier for me to say. But thank you, chat, for talking about the facts of the thing. It's hard to talk about. So, all of it's hard to talk about. But what's good news for the prosecution is that there was no one else. There was no one else on payroll during that time. Ouch. That's got to hurt the defense. They know that that's there, but that hurts. This individual also told law enforcement that he was very inexperienced with computers and did not have any social media accounts. After obtaining consent, they reviewed the individual's phone on the scene without the use of a forensic tool. They said, hey, can we look at your phone? He said, yeah, this is the passcode. And they looked at the phone. They found no evidence of criminal activity on it and returned the device. They were looking for Tors. They did not see one. That's my assumption. Following the execution of the search warrant, law enforcement interviewed multiple individuals in connection with the investigation. One of these individuals, referred to as witness 1 in the defense motion, was interviewed on December 16th. This individual told law enforcement that he had purchased multiple vehicles from defendant, but denied ever entering the small office on the car lot without an employee present. He demonstrated no familiarity with peer-to-peer file sharing programs and said he was not in the vicinity of the car lot on May 2019. During the interview, he allowed law enforcement to manually review his cell phone, which he had recently purchased in October 2019 without the use of a forensic tool. They found no evidence of CSAM on the phone and returned the device to the individual. On December 2019, law enforcement interviewed another individual, witness 2. During that interview, the individual advised that he worked at the car lot from 2017 to 2018, after which he left to start his own business. You ready for the whoop? There it is. This individual told law enforcement that the internet at the car lot was password protected and therefore not accessible to the public. He acknowledged using the defendant's computer when he worked at the lot, but demonstrated no familiarity with peer-to-peer file sharing programs and denied ever accessing porn on the computer. He also advised law enforcement that the defendant's computer at the car lot had a program known as Covenant Eyes installed on it, which would notify defendant's wife if the device was used to view porn. At that, the defendant told him and that the defendant, Duggar, told him that he struggled with a porn addiction. Finally, this individual reported that he did not believe witness 1 was very computer savvy and that witness 1 had never mentioned using peer-to-peer file sharing software. The individual also allowed law enforcement to examine his cell phone during the interview. Law enforcement found no evidence of CSAM in that review of the phone. The evidence recovered from defendant's electronic devices seized during the execution of the search warrant, including his Apple iPhone, laptop, computer, desktop, had established that the defendant was on the lot in May 2019 when the IP address was used to distribute the CSAM over the peer-to-peer network, and that the computer in the small office was used to download the CSAM. And then they go through their argument. But what we learned from those three witnesses is that the one that used the work computer knew that it had the monitoring program and didn't seem to be aware of the partition drive. And most people who aren't partitioned or aren't aware of partition drive wouldn't even know how to log into the partition drive, depending on how you get it. Most partition drives, you have to do the startup and you have to partition them. I've partitioned computers when I needed to run Windows for stuff for work on my Macs. And so I have a partition. And at the DA's office, when I needed to look at sketchy shit, I had a partition drive so that it wouldn't A, infect the work network, B, wouldn't get into my computer, and B, would allow me to view sketchy shit for work purposes without infecting everything. So it's like the mirror dimension for some of these partitions, if that makes any sense to my geeks out there, to all the nerds, you know what I mean. So what we learned from those three witnesses is that during the time that the images were possessed and downloaded on the computer, no one else was working at the lot, and that others used the internet there, but they had no evidence on the computer or on the devices that they were using it, and that the partition of the computer that did the thing, because that's where they found it during forensics, was password protected with a password that Duggar used for his bank account and used his birth date in it. So that is the evidence they are going to present to a jury if this goes to trial later on this year, early next year. I forget the exact trial date. So they then go through all the legal arguments that are going to disallow the argument that, see, you didn't preserve these phones and therefore we don't have the evidence. They go through all of that, saying that these were not a denial of his due process, that there is no bad faith, that those phones were determined not to have anything, that they're not exculpatory material, and they don't require saving. We have one more that I'm going to talk about real quick, and then we are going to move on to questions, because the appointments clause argument was very novel. We went through it quite a lot. It is a thickly legal argument. There's not really much tea here. It's just very, very interesting the way that they argued it. And if you guys are interested, let me know. We'll get into the appointments clause argument more later. They say that defendant contends that acting secretaries McAllen and Wolf filled the position of acting secretary of Homeland Security in violation of the appointments clause. The government's argument is that the court need not reach the constitutional and statutory questions. You don't even need to go there, Your Honor. We don't even get there. This is not relevant to our case. The court does not even need to worry themselves about the constitutional and statutory questions raised by the defendant's motion, because the grand jury is the ultimate investigating authority and returned the indictment, and the U.S. Attorney's Office is the one that's authorized to prosecute the case. So there's not an appointments clause issue because the U.S. Attorney's Office is prosecuting, not Homeland Security. They were just the investigators. Furthermore, regardless of whether the position of acting secretary was properly filled at the time, the HSI agents involved had statutory authority to conduct this investigation, and the defendant does not even suggest, nor do the facts support, that the acting secretaries took any action that affected this investigation. Even if there was an appointments clause issue, they still have statutory authority to investigate, so it doesn't affect this case. Finally, if the court were to reach the issue, the acting secretaries were in compliance with the appointments clause. And this is a 169-page motion. Those are the arguments, very concisely laid out. I am curious to see if the court does a constitutional analysis, or if the court goes, you know what, this does not impact our case because HSI has statutory authority. The U.S. Attorney's Office is the one who's prosecuting it, and this does not matter. It will be very, very interesting to see. So that's the appointments clause. They're asking the court to deny the motion. Of course, they attach so much information with regard to the appointments. They attach a whole ass declaration by one of the acting. Let me just pull up the declaration real quick because they did the most. Like the government did not spare any time going, this is a novel argument. The court's never going to address it. They hit this head on and brought in a declaration from Juliana Blackwell. Let's see, I've made it too big, so now I can't see. Sorry. We're dealing with me not being able to. There we go. Who is the deputy executive secretary within the office of the executive secretary within the Department of Homeland Security. And this is the individual that lays the foundation for all of the orders of succession and petitions. And they attach all of it. Like they attach all of the authority saying that these people were properly appointed and actually went to the executive secretary to lay the foundation for it. So they absolutely went through quite a thorough analysis on every single one of these motions. But I have been live for 2 hours, so we are not going to go over that because I have questions and you have questions and we have questions. I know I've missed some super chats. I will try to swoop them the best I can. But I have questions, you have questions. Please put questions. And because we've covered so much today, questions about the topics that we've covered today. I know we have questions about, I will talk about Britney's Instagram in just a second. I know there's questions about other stuff going on in the internet. I will address them another day, I promise. Today, not today. So let us get to questions. All right, 2, 1, cues. I'm writing down my timestamps. I'm writing them down. Let's get to questions the best we can. Question, during trial, does the jury have to see all of the CP images? There will be evidentiary motions about what the jury has to see. The jury will have to see some of them because they have to violate the definition of the law. So yes, the jury will have to see some of them. They do their best to sanitize them, but yes, the jury has to see them. And it's something that comes up when questioning the jury, if this goes to jury. The thing about that is the prosecutors I've known who have done cases like this, the defendant is innocent till proven guilty, right? These are allegations until it's proved that to a jury that he was the person behind the keyboard doing the things they're accusing him of. But oftentimes jurors are so angered that they have been forced to sit through it, especially when the evidence is strong, that it is very hard for a defendant to overcome the weight of the evidence and almost the shock and horror of the jury about what was done, because the jurors, people are savvy. They know that he could have pled. They know that that's a reasonable option. And so jurors get very frustrated knowing like, you are making us be here. And they do tend to hold that against the defendant. They don't mean to, but it does happen. And I've seen jurors get very frustrated. Like, you made us sit through this. You made us sit through this. Only one Synergy encrypt your passwords. Yes, I use a password manager, and NordPass has been a very, very generous sponsor of my content and the stream, and they do that. So, yep. Question. Can you please invite Robert Barnes as a guest before the court can limit what Kyle Rittenhouse T. Barnes can spell? I will absolutely reach out to Barnes. I've been wanting to talk to him about the attorney that got yeeted off of Rittenhouse anyway. So, yes. Did the court have the right to not notify Britney about the conservatorship? The statute said shall not may be notified. I have to look at it. I have pulled up all of the determinations where the court said that they weren't notifying her. Shall generally means shall. It's just very interesting to me the way that it all got so locked down. Shall means you must, but it also looks like Ingham waived her notice for some of these things. And so if Ingham was appointed and Ingham was notified and then he waived notice, the problem is, how was Ingham notified? Like, it's layers and layers and layers and layers of stuff. And it is a problem. So, question, since this case is so well known / infamous, could the defense argue he won't get a fair trial? What could the prosecution do to counteract that? They will they could always move venue if they are worried about it. They haven't made those motions yet. And they would do a really thorough vetting of the jury. You're always going to find people in any kind of high profile case that haven't heard of the case. They sat a jury in like 4 days in the Elizabeth Holmes trial. So they will do surveys of the jury to ask them what they know and go from there. So that is always a consideration for the defense in a high profile case. And it is always dealt with by the court, sometimes with change of venue, but often not with change of venue, often just with questioning the jury. So I'm going to try to get to a few of the super chats that I saw that I had missed. Susan said, can he use a computer or cell phone now? Susan, he can't. When I talked about the detention hearing, I talked about the conditions of release, and the conditions of release included no accessing the internet. Kendra Kraft, how are you doing with the Duggar case mentally and emotionally? Fine. Fine. I'm not unfamiliar with cases like this, and so I'm also not in it trying to prosecute it. So for me, commenting on it is not as emotionally invested as the weight of prosecuting something and feeling like the weight of getting justice is on my shoulders. This is just the weight I feel is helping people understand how cases like this happen. And the biggest concern I have is that somehow those who would like to do nefarious things on the internet will use my commentary as a resource for being better at not getting caught. And I'm always very mindful of that. So there are things I do not get into in too much detail. There are things I choose to leave out of my commentary because I want it to be instructive for the law nerds to understand what's happening in the cases that we're all fascinated by, but not instructive enough to help those that would seek to hide their behavior. Again, I'm of two minds. Like I'm a former prosecutor. I also don't want the government monitoring everything we do on the internet and being like, oh, you're talking to them. I think they're a problem. So maybe you're a problem too. So can Britney sue Ingham for malpractice? I think in role of court-appointed counsel, Ingham has immunity for that. Now, if there was malfeasance, I think that could be looked into. But for general duties, I think that he has immunity by being court-appointed, but I would need to look. Alexis, do VPNs work on phones? Yes, they do. I use NordVPN on my phone, particularly when I'm traveling. Like, I'm not hopping on Wi-Fi at the Sky Club without having a VPN on my phone. DeFranco does. Thanks for doing what you do, Emily. Thank you so much. And thank you for the super chat. Appreciate it. Let's see. I missed a few more. Sarah said he should have kept his trap shut. If you're not a criminal, you shouldn't know why they are there. When the police came and questioned me about my ex-husband, I figured out that they were investigating what they were investigating based on the questions. And if you know enough to know why they're there, you can put it together by their questions. But look, you have a constitutional right to not talk to the police. You can go ahead and exercise that right, but you have to exercise that right. The police aren't going to exercise it for you. Also, as a prosecutor, it always makes it easier when people talk to the police. So I'm of two minds. One, you have a right, feel free to exercise it. And two, if you would like to help prosecutors out, go ahead and continue talking to the police because it makes it much easier to prosecute things that people do. And if you're just a witness, and not a target of investigation, you don't have all of the same constitutional rights. But generally, you can say, I don't have to talk to you. Law nerd clips, yes. I missed the end of that. Also, can I please use short clips of you calling out fuckery, silly clips on my channel? If they're fair use, I never, ever have an issue with fair use clips, as long as they are within the bounds of the guidelines on YouTube. You know, all the things. I'm behind on the stream, but Shake Shack is greater than In-N-Out. I mean, you're choosing violence today, but I like it. A lot of people don't love In-N-Out. In-N-Out burgers are great. Their fries are not my favorite, but I do love an In-N-Out burger and I do love a shake. Megan, would they tell him not to leave the state? Not at that time. They didn't have a reason to tell him not to leave the state. He was not under an arrest for like a year after they came knocking. So now he can't leave the state, but he could have traveled in between the time that they did the warrant at the car lot and the time he was arrested. They could have absolutely traveled. So, um, I think I'm at almost all of them. Uncovering hypocrisy. Hello. Scary part is um, doesn't that sort of mean that his wife was suspect of what he could potentially be doing if she was keeping tabs on him? I think this is regarding the covenant, the covered. I said that's so weird regarding the covenant eyes situation. And yes, she was keeping an eye on him. Whether she knew that that predilection was for of the adult age or not of the adult age, I don't know. But there are things in the past where I think she would have had a heads up to there being some issues with those that are underage with regard to the things that happened with his sister. So I can't imagine she was completely unaware. But yes, if he was saying, "Oh no, it's just adulty stuff that is the problem. It's just the adult PORN." I don't know how much willful blindness is going on there. I don't know. Question: have Duggar's children been interviewed yet? I don't know. They were trying to investigate them, or not investigate them. They were trying to interview them, but in the detention hearing, they had not been able to do that. I don't know if they've been able to do that yet or not. I have not seen anything to indicate that on the in the court filings. So I don't think so. Let me see. I'm going to do a few more questions and then I have to bounce because we still have things to do, but we will be back Friday for Friday Night Live. And if anything else goes crazy, then we will see what we can do. Does a VPN make it hard to log on to things? Only certain things and generally not. If I am trying to access a site that is blocked because of VPN, um, Nord is for me, and again, they are a sponsor of the channel, but Nord for me is really easy to unblock or turn off access to sites I need to and turn back on. Some government sites and stuff you cannot access with a VPN turned on. So hopefully that helps. Coveted Eye sounds like something from The Handmaid's Tale. Yes, it does. Yeah, you can Google that. We've done it on stream before. We've gone to the Covenant Eyes sales page website. That's not going to like it might flag your computer for some advertisements that you might not want to see, but it is kind of a fascinating program. So you can go look for sure. Could Duggar have gotten a new phone after his was seized before the arrest? He absolutely could have. He probably did, but they were looking particularly for evidence regarding those May dates. That's what they had a search warrant for, those May 2019 dates that are alleged in this case. So a subsequent phone wouldn't have mattered because it wouldn't have had evidence on it for this. He can't use it right now. I don't know if they would have taken it, but he can't have it right now. So, sorry, my nose was getting all stuffy. Question regarding Duggar. If Anna is staying with Duggar at the third party house, and again, for those who aren't like following this case in and out, I get it. And you keep talking about In and Out the burger. Now it's just going to flow into all of the things. Duggar is out on house arrest, but he's ordered to not be around children without supervision. Well, he can't be around any children, but he can be around his children if his wife is present. He is staying at a house arrest house of what seems to be a friend of his father's or a friend of the family that goes to church with them. I have seen reports that Anna is staying with him at that house without the children, but no, she can be with him without the children. There's no restriction on that. He can't use the internet. She shouldn't be using the internet on his behalf and things like that. I don't necessarily feel confident that those who Duggar is staying with would report any bad behavior on his part. I'm just not confident in that. That's how I took it. They testified at the detention hearing. And I did not get a strong sense that those he was staying with would be like, oh yeah, I will absolutely, if he's accessing the internet or has a third party accessing the internet, I would absolutely say something about it. I didn't get that vibe. I didn't get that vibe. And yeah, the court didn't have a problem with it. The prosecutors had a problem with it, but the court gets to decide. If Josh is convicted, could he face a lesser sentence because he has 7 children, which will include a newborn? There is always a sentencing range in federal crimes. I think the allegations, if he is convicted of them, plus the fact that he has children, will not go in his favor. I think the fact that he has children will go against him when the court looks at the mitigation and aggravation in sentencing. Just a real quick law nerdy, like, Emily, you say these words. Mitigation from a sentencing guidelines, and sentencing guidelines have a range for different crimes. These are, I don't know off the top of my head. Let's see. I can pull up it's probably not necessary. It's probably just me being extra, but I'll pull up the indictment. It should say in there. They're going to be into like the 20-year range, but there's a range of sentencing guidelines so that judges can't just go ham and give you like no time, or go ham and give you all the time. There are ways that judges can depart upward. There are ways that judges can depart downward, but there's a range. Mitigation means things that mean you should get less time, things that mitigate the sentence. Aggravation means things that make it worse and you should get more time. And judges will have sentencing hearings and hear from victims in certain cases, hear from the prosecution, hear from the defendant sometimes, hear from defense counsel, hear from those that support the defendant and want to say what a great person they are and all of that. So they will see those factors in aggregation and mitigation. I don't think the amount of children he has on a CP charge will help him be sentenced to less. Let me see. No, the sentencing guidelines aren't in here. I'll have to pull them up on another, but it's upwards of 20 years. And it also has the allegation of minors under the age of 12. So there could be some factors in aggregation making it goes up, making the sentencing go up. Mother Oats, what is the statute of limitations for a conservative to sue somebody? I mean, I imagine it wouldn't be until the conservatorship ends and then start, but I would have to look from there because they might not know and they might not be aware of what's going on inside of it. Question, Tracy, we did this earlier in the stream, but yes, and they are on social as well. That is one. That is the other one. That is the best. That is the best we can do. Yeah, Cynthia, I'm not here to question I have questions about people's judgment, but I don't think that violates their sentencing or their conditions of release. It's just, I mean, I want to be with my kids. My kids, if my family were going through something awful, I think that my kids would need me most. And I think that's true for most families. If you're going through something, though you might think your spouse needs you, your kids need you too. Your spouse is an adult. So Cynthia said the family he's staying with, their daughter just got engaged to Anna's brother. Right. Do you think they would turn him in? I didn't get the vibe that they were going to be like, yep, if he steps out of line, we got you. Didn't get that vibe. The prosecutors didn't get that vibe. So, yeah, Dakota, thank you. I think it leans towards, would they actually say he did something wrong? I don't think that they would. I just don't. I've never had In-N-Out or Shake Shack, but they can't be better than Five Guys. We're going to have to do a ranking your U.S. burger chains for one of these courts of public opinion, because also Steak and Shake is at the top of that list. Fight me. And I don't want you coming in here with your what a burger, whatever. Steak and Shake's better. Sonic, also pretty fucking legit. So, and I like Steak and Shake better than Five Guys. And I like Steak and Shake better. Shake Shack's good, but I think I like Steak and Shake better than Shake Shack. Shake Shack's a little fancier than Steak and Shake. But Steak and Shake is a new love because they didn't have them in Southern California. So maybe I am swayed by its shiny newness, but I love it. Thank you for giving us the facts. Money for demonetization, important topics to discuss, and I understand. I love the laundry community. Well, thank you so much for the support. We will see if this one gets demonetized. I intentionally demonetized the detention hearing. I know not everybody could attend it. I didn't want to monetize that video. Some of the stuff that came out in the detention hearing was just so dark. But that video, I think has almost 500,000 views on it. So when we make the decisions, I still stand by the decision, but I wanted to provide factual facts, not fuckery, with regard to the detention hearing. And since I had sat through the whole thing, I didn't want to monetize that. It just didn't feel right to me. So, um, what about the email saying he was offered a plea? I didn't go through all the emails. He was offered a plea. There's a date for the pleas. He has not pled at this point, but almost every federal criminal defendant is offered a plea. Um, so Ashley Vincent, I love Islands. I don't think Islands gets into our fast food chain because they never have a drive-through. Their fries are amazing. Their burgers are amazing. And it's one of the first places we ate when we went back to California with the kids. We absolutely love Islands. So yes, he was offered a plea. But again, that's not, for me, that's not like, oh wow, he was offered a plea. Federal defendants are offered pleas. Like 90+% of their cases plea. After the judge rules on this, there might be a plea. Um, let me pull up the government response with all of the emails. If you guys want to see it, I'll just pull it up real quick. Let's see. Not that one. I forget which motion it's in. There were so many of these, and we still have H3 motions to go over on Friday. So let's see. Here. This is in the response to the motion to suppress. There are quite a lot of emails back and forth. In this, I did not pull up everything. This is the 212-page motion. But if you guys want to know, we'll just do it. We'll just do it. To recap our meeting today at Homeland Security regarding the proposed receipt of CP plea offer, the government provided defense counsel with an oral review of discovery material, which is going to be everything we talked about and possibly more, saying, hey, this is how we're proving our case, by the way. So this is how we're proving our case against you. So if you would like to just plea, you might want to do that. The government displayed the Marissa images and the video of the CP downloaded by law enforcement to defense counsel. They showed defense counsel what is alleged to have been looked at. The government offered a review of all the CP images discovered during the forensic process, but that offer was declined. No shit. Most attorneys are going to be like, I don't need to see all that. Thanks. During the meeting, defense counsel inquired about the law enforcement agency that did the initial CP downloads. The attorney for the government stated it was Little Rock. There was also an inquiry from the defense about the procedure the case will follow if there is not a plea to an information, and the government indicated it would follow the normal course of any CP case. The defense likewise inquired about the acceptable sentencing guidelines. The government's attorney stated that the defendant would hit all enhancements, which would likely result in a guideline recommendation sentence around 10 years. However, there's no oral agreement as to sentence or promise regarding the accuracy of the guideline estimate. So they're saying, look, this would probably be like a 10-year case after trial. Also, during that meeting, there was a request for the Little Rock download logs. This is something they're still fighting over. The government does not have that information at this time. They were ordered to turn it over, though, whatever was in their possession. Lastly, there was a request that the government provide a number of images from the Marissa file that were not downloaded. The government does not have further responsive information beyond what's identified in the download logs. And this went back and forth. This is just them meeting up. So let me see if there's another one, because I don't remember off the top of my head. Because again, pleas are not uncommon. Being offered a plea deal is not uncommon. It is not, let's see. As for the grand jury date, that is a set minus a signed plea agreement. So they are talking back and forth about it. I mean, they absolutely will have, these conversations. The next email says the plea agreement contains a statement of facts, which should be a good summary reference when you are reviewing the discovery material. Significantly, Duggar's cell phone included text messages he sent and pictures he took that places him at the car lot on the dates and times that the CP images were downloaded and distributed. There are several reports that set out the forensics evidence that establishes his physical whereabouts, particularly ROI number 12, which focuses on May 15th. And then they talk about a next day. So they are just going through, hey, this is what it is. Attached are the government's, another email, attached are the government's proposed documents included in the information calendar, plea agreement, waiver of indictment. Let us know if you have any questions. Also today we are uploading a couple of additional documents to the e-discovery and the plea agreements there too, the affidavits. The plea agreement, again, is something that the government would have prepared at the beginning of this and been like, hey, here's all your information. Here it is. Do you want to plead? Do you want to go to trial? How do you want to do? So this is what it is. Question, how late in the day can Josh wait until making a deal? We talked about that. There is a deadline. Let me pull it up in my notes. There's a deadline for the plea agreement set out by the court in one of their last motions. And I pulled that date into my notes. Let's see. Change of plea no later than October 18th, noticed to the court and signed by October 20th. So October 20th is the drop dead date for a signed plea agreement, but the court must be notified of a change in plea by October 18th. So go ahead and put it in your calendar. October 18th is the day that the court has to receive notice. And if the court receives notice, it should be in writing and we should see it. So we will definitely be keeping eye on what's going on in court between the 18th and the 20th to see if he changes his plea. I wouldn't be surprised if he does. Tater tot fondue sounds delicious. Y'all making me hungry. Please go to Burger Republic and get tater tot fondue. Yes, my husband and I love tater tots. We are supposed to be going to a concert. You can hear that I'm still concerty. We are supposed to be going to a concert. Maybe we'll have to go to dinner before. We'll find it. All right, y'all. It has been 2.5 hours. A huge thank you to our amazing moderators for riding today. Thank you, Law Nerds, for being so amazing. We had well over 4,000 of you this entire stream. Thank you, thank you, thank you, thank you, thank you. I'm going to answer one last question, Bree, because I adore you and because this is a very, very good question. Almost every single case brought by the AUSAs, they offer a plea deal. Almost every single case. So yes, in a case that is not involving like special circumstances, death penalty, homicide cases, someone's going to get a plea deal. And if the U.S. Attorney's Office didn't do it, the courts would lose their fucking minds because there is not the time or room to go to trial on all of these cases. In the grand scheme of things, in criminal prosecution at the level of a U.S. Attorney's Office, this is not a huge case. This is a 2-count case of possession. It is, they believe it's about a 10-year case after trial. That is not a huge deal. Huge deal cases are the cases that are like 400 years to life plus go fuck yourself. Those are cases. So I'm not surprised that they offered a plea deal. Most cases get offered a plea deal at the beginning of the case, and it saves court time and energy and resources. It's like, I know you did something. You know you did something. Would you like the benefit of saying that you did something early? Because then you will get less time for early admission of guilt, for accepting what you did. But you fight us all the way to the end, and you're going to get more time. And that's the way it is. So not weird at all. Not weird at all. But I don't know how to say this with it. Hopefully it will just make sense. In the world of prosecution, these types of cases, though horrific, the possession cases aren't uncommon. They're not unusual, and they don't carry a ton of time. The creation cases, the hands-on cases, those kinds of things carry more time and carry more consequences than just downloading, possessing, and looking at. So these cases are not considered to be the like worst of the worst of the worst on the scale of criminal prosecution. No matter how much you don't like a defendant, no matter how much we as a society are like, this is fucked and we hate these cases. This is not the biggest type of case that the U.S. Attorney's Office comes across. So that's that all goes into it too. And that's why when they're saying it's probably a 10-year case, yeah. And for a lot of you, that probably doesn't feel like enough. And I get that. But in the scope of things, it is not the worst of the worst of the worst of the worst. What he was viewing is the worst of the worst of the worst. It is. And the creation of those gets prosecuted separately. So that Molly Moo, I do not have the minimum sentencing on this on the top of my brain, and we do not know what he was offered in a plea deal. That is not for public information. If he please, we'll know. And then I'll be able to juxtapose it. Now I have to go get a burger. Well, apparently it's National Burger Day, so it's good that we're all talking about it. I want a burger too. So thank you guys. Ashley, there we go. Now I have to ask, when you go to SLO, Moe's Barbecue or Fry, I have not been to Moe's yet. I've not been to Firestone Grill, and I don't know what you mean by slow, but message me. All right. My brain is tired. My voice is tired. It's time to go eat. Thank you, thank you, thank you, thank you, thank you for being here. Thank you for being law nerds. Thank you for valuing facts, not fuckery. Thank you to the mods for the ride. I will see you all on Friday. There is so much going on, and then we will start getting into all of the other, there's a lot of other stuff going on around the interwebs. I will try to get to some summaries. So yeah, thank you. We will see you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.